Hello Realtors, Byron King, your Chief Legal Officer. I'm standing in from Nick Cremitis today. Mike Christ is on the production board as usual. Nick and President Keon, probably your association executives and your incoming leadership are in Chicago this week for leadership training. Today I wanted to go over kind of our hotlines, Form 120, and then a new consumer guide for buyer agreements that NAR has put out. So first, let's jump into the compensation agreement. This is a one-page document. Prior to the MLS rules changes, you probably only use this document if you're working a buyer that was buying a for sale by owner, an unlisted seller for sale by owner, or say you are working a buyer in a multiple listing service that your brokerage did not participate in. But the MLS rules have changed, as everybody knows, so this one-page compensation agreement has become much more important because it kind of takes us back to when multiple listing services started in Chicago that replaced this document. We're back full circle to this compensation agreement. So I'm going to go through some of the hotlines, some of the questions we've been getting on the hotlines. This has probably been one of our top hotlines. But Form 120 and Austin Smallwood's done a short video on our YouTube channel, on our website, if you want to watch that as well. But Section 1, mistakes we're seeing. Section 1 is just for the person paying. So whoever's sending the money, they go in Section 1. So Section 1 could be the listing brokerage is paying. So you would check box listing brokerage and then type in the listing brokerage name. Or you might have the seller paying. So you would just check box seller and then write in the seller's name. So whoever the paying party is, listing brokerage, you fill that out. You no need to put in seller and buyer names there. If the seller's paying, you check box seller, put their name. In that case, no reason to put listing broker and buyer. So common mistakes we're seeing, realtors are filling in all three of those because in the deal there might be a listing brokerage, there might be a seller and a buyer, but that's incorrect usage of the form. So Section 1, only the person that's paying the money goes in Section 1. That could be the listing brokerage, it could be the seller, it could be the buyer, but that's pretty rare. So you're probably going to see either listing brokerage or seller there, but you would never write in all three in those blanks of Section 1. Below those check boxes is the person that's getting the money. That's typically the buyer brokerage. So you're going to write in the buyer brokerage name. So Section 1, parties agree in this legally binding compensation agreement. Typically it's going to be listing brokerage or seller. Agrees to compensate the buyer brokerage. And then Section 2 is why they're being paid. So typically you're going to check box buying on the behalf of, write in the buyer or buyer's name there. And this is kind of a Swiss Army knife form, which is, I think, creating some confusion because it can be used in a lot of scenarios. But below that, where it says checkbox listing, leasing or renting or other, those are rare. Call the hotline if you're going to use those. But for the typical transaction where this is replacing the multiple listing, either listing brokerage or sellers paying, they're paying the buyer brokerage. And for the activity, checkbox buying on behalf of the buyer or buyer's names. And then Section 3, most people are getting this right. This is just where you fill in the property. You describe the property that's being bought. That's pretty easy. Section 4, terms. Typically, that's going to start the day you're signing this thing. So today's date, you'd put that in, the 26th, and expiring. My recommendation is put a date that's past closing. That would include the closing date. Maybe, if it gets extended, maybe a week or two past closing date would be something you could put in for terms. Section 5, compensation. You're either going to put a percentage or a flat dollar amount. So I like to say bacon so we don't get into antitrust issues. So you could fill in bacon percent of the gross sales price or flat fee of $ bacon. These other blanks and check boxes, call the hotline if you're using those. Those are rarely used, but again, this form is designed to be used in a lot of situations. So call the hotline if you're not putting bacon percent or bacon flat fee in there. And no need to put both. No need to fill out bacon percent and bacon dollars. Just pick one or the other. And then checkbox, it's going to be paid at the closing of the property. And again, those other check boxes in Section 4 for assumption of lease or otherwise agreed, call the hotline. Those are rarely used. Those are used when you need to tailor to some specific situation. and then the seller blanks down below. So typically the buyer brokerage is filling this out, likely to send it along ahead of the offer, along with the offer for the seller to pay or the listing brokerage to pay. So line 1 in the signatures is typically going to be the buyer brokerage signing with a date and time. And you're going to see either the broker in charge signing, or maybe the broker in charge has delegated this to an associated licensee. So they're going to sign there. My recommendation, because not all signatures are legible or even who you work for. So if you're the broker in charge of the associated licensee, so it's on Byron King, and then I'd probably put, at SCR Realty, for example, and the date and time. And then that would be sent, and whoever is going to pay the money, be that the listing broker or a seller, would probably sign the next line. Listing broker, you could write in, Byron King at listing brokerage, SCR Realty kind of thing there. And there's 4 blanks there. If you need extra lines, say the seller was going to pay and you've got 5 sellers, which would be unusual. You could always use Form 390 General Addendum to extend those using Form 390. So those are kind of the common hotlines we've been seeing on that. But call the hotline, 803-712-3478, if you have any questions about the compensation agreement. That's one of our top hotlines. And I'll just run through our hotlines. Thanks to CFO Allen for creating these. Number 1, forms and seller class action lawsuit questions, obviously. Number 2, advertising under the new license law that was passed in May. General questions about license law that was passed in May. Ethics issues, state law issues always tops. Agency and disclosure. Number 8, brokerage, broker in charge, and broker management, risk management. Number 9, compensation issues under the new MLS rules. The 120 we just went over was number 9. And number 10, the new MLS rules. So you can kind of see 120 kind of hits number 1 and number 8 and number 9 and number 10 with one form. So that's how I wanted to go over that. Sharon Stone is putting it in the weekly report. Nick sent this out in an email. NER has come up with a new consumer guide to written buyer agreements. It's a 1-page document. This is a good document to print. Incorporate that in your scripts. Make sure you sign up for our ABR training. SRS is this week, so sign up for SRS on our website, screaltors.org. NER is running ABR training. We're rerunning in the fall ABR, SRS, RENE, PSA, the pricing strategies. All those courses are included in your membership. Todd Beck's going to be teaching SRS this week. Sign up for that. All these are Zoom trainings. They're excellent trainings. All of them are included in your membership. So this document, the Consumer Guide to Written Buyer Agreements, talks about what is a buyer agreement. It's basically a document between the buyer and the buyer brokerage. It covers what if a buyer says, hey, why have I got to sign this buyer agreement? You can talk about Article 9, the new MLS rules. We've got to do this before showings, virtual and in-person showings. Are these agreements new? South Carolina's had these agreements since circa 1994, 1995, when buyer agency was legalized in South Carolina. Not all states are like that. Some states are adding buyer agency as recently as this summer, as part of getting ready for the settlement changes in MLS rules. Are these agreements negotiable? Your broker in charge will set a pricing policy. But if an individual client wants to negotiate with your brokerage, make sure you contact with your broker in charge about maybe getting an override decision on your brokerage policy. But in general, in the industry, all agreements are not set by law and always fully negotiable. But brokers in charge and brokerages can set their individual pricing. That's their pricing for their brokerage, individual business decisions. It says how do buyers benefit from these agreements. These agreements clearly lay out the services you're receiving and the amount of compensation. So it's basically kind of a disclosure and an understanding between what the buyer is expected to do, what the buyer brokerage is expected to do, and how the money is handled for those services. Because realtors, you're providing a service, you're navigating buyers through a significant transaction in their lives. You have a lot of knowledge and experience as a realtor. So you're providing a service, and this document lays out what you're providing as that service and how you're getting paid. And then it says, when do I need to sign the agreement under the new MLS rules, the settlement rules? Those documents should be in place prior to touring a listed property listed with another brokerage. But That could be a virtual tour or an in-person tour. Now, if you have the listing, your brokerage has the listing, and you're working for your seller client, your brokerage's seller client, technically you can show buyer customers those listings without an agreement. That also covers your open houses, but that's only if it's listed with your brokerage, because you're working for your seller client, and obviously you would disclose that in your government form, the SCR 110, which is your disclosure of real estate brokerage relationships. Another question that's come up on the hotline about showings: what about friends or cousins or parents that want to come along on a showing? You can bring those along. You'd have the written agreement with the potential buyers. For fair housing reasons, you probably want to use forewarn on if you don't know these folks, to make sure they are who they say they are, checking their IDs and their vehicles. All your safety protocols with your office, always apply those evenly for fair housing. One good thing about buyer agreements is they typically require the buyers to behave reasonably in the listings. That means, no sticky fingers, don't take anything, don't vandalize anything, don't eat food that's in the listing. And it's a good idea to talk about buyers if they have young children. Teenagers might want to have some input on their new home, but young children or babies, maybe try to use some child care just for safety reasons, because you are worried about slips and falls and injuries inside the listings, or even if somebody were to turn the stove on, create a fire that burns the listing, or leave a faucet on that floods the listing. So always resecure the listing once you've done your showing, buyer brokerages. And then it talks about, how do I pay my real estate, my buyer brokerage? Do I pay out of pocket? Yes, the buyer paying their buyer brokerage is always kind of the simplest and easy procedure, but it's not ideal in a variety of reasons for that. So you may see a listing broker pay the buyer brokerage. You may see the seller pay the buyer brokerage, and you're going to use that Form 120 that we went over at the beginning. It says, do agreements dictate a specific type of relationship I have with my buyer brokerage? So in South Carolina, we have agency agreements and non-agency agreements. Non-agency is called transaction brokerage agreements. So our standard forms, you're going to see SCR 130 used a lot of times. That's your exclusive right to buy, buyer agency agreement. 135, your non-exclusive buyer agency agreement. 136, 138, your transaction brokerage. And in South Carolina, we also have sub-agency, which is rarely used. We also have dual agency or designated agency that could kick in if you have a buyer client wanting to buy one of your brokerage's listings. But call the hotline if you have any questions about that. And then it says, hey, this is a legal agreement. What can I do to change it or exit this agreement? So it's a legal contract. It's binding. So you're going to explain that to your buyer clients or even buyer customers if they're executing a transaction brokerage buyer agreement. That is a legally binding agreement. You've agreed to work with me for these services. You typically describe the property that the buyer wants you to search for. And if a buyer breaches that, they unilaterally terminate you without cause. Theoretically, you could hire a trial lawyer and sue them. A lot of times the trial lawyers or the brokerage will probably just contact the buyer to try to work out a settlement for some amount of money on that. So it's a legal contract. If somebody wants to get out of it, they need to talk to their trial lawyer. And as an agent, if some buyer comes to you and says, I signed one of these with another brokerage, you have to be very careful because there's license law and ethics involved if you interfere in that relationship. You're always safest to refer that buyer to talk to their trial lawyer ASAP, mainly because of these potential for breaching that agreement. One thing that's come up on the hotline in the buyer agency agreements, if it asks, when you describe what they're searching for, say every house between $400,000 and $450,000 in Lexington County, South Carolina, then you search that, you present all those listings, and then you discuss, hey, this one, they've advertised co-op, this one hasn't, but they may be open to negotiations. Have those discussions with your buyer. Never filter or steer a buyer. Give the buyer all the properties that meet their criteria, and then have a discussion about compensation. Since the MLS no longer has an offer of compensation that's enforceable, technically any advertisement of cooperation and cooperating compensation is not enforceable until you get that reduced into a Form 120. All right, so we're about to wrap up. Call the hotline if you have any questions on Form 120. Get a hold of this consumer guide to buyer agreements. That's going to be in our weekly update this week. And then summary, if you need to reach us, our emails are just our first names, Byron at screaltors.org, Austin at screaltors.org, tpitts at screaltors.org for Tierra. Our phone number 803-712-3478. You'll talk to our newly promoted operations assistant, Shante Alban. She'll be very happy to connect you with one of the lawyers. And again, the legal hotline will be open this Saturday and Sunday from 12 p.m. to 5 p.m. Try to handle all your settlement questions and legal hotline questions. So thanks, Mike. Thanks for producing always. That wraps up this legal update. Keep it safe, legal, and profitable. Thank you.